respected seniors and my colleagues at the bar, dear friends, I welcome you to the first season of Lex Talk, brought to you by BFS Legal. Mr. ARL Sundaresan is our distinguished guest today. That Mr. Sundaresan is an eminent advocate and president of the Madras Bar Association is known to most of us. Mr. Sundaresan was designated as a senior advocate at the age of 38 years on account of his knowledge of law and brilliance in court. Over the years, Mr. Sundaresan has argued several landmark cases in all the branches of law. Mr. Sundaresan continues to inspire young and old by his legal acumen and court craft. His pleasing manners and warm ways are known to everyone who has interacted with him. Therefore, it is no surprise that he continues to be the most engaged senior advocate in the Madras High Court. Sir, I welcome you and request you to enlighten us with your views on equitable principles in transfer of title in immovable property.
Thank you, Asim. Am I audible?
Yes, sir.
Is the audio clear?
Yes, sir, it's clear.
Asim, is the audio clear?
Audio is clear, sir.
Okay. Good evening, friends. I thank BFS Legal, the organizer of this lecture, for having given me the opportunity to be the speaker in the first lecture in a series which is to be organized by them. I also thank all the persons who are logged in and are attending this lecture, sparing their time of nearly about 1 hour. Thank you all. All of us know there are a number of lectures on various platforms on subjects of law being conducted by various advocates and firms. During the period of lockdown, to keep us engaged in some manner in connection with our profession is very important. And at the same time, we also like to refresh our mind to various aspects of law, which probably we might have learned at the time of law college, or sometimes even might have left in choice in a question paper. We might have come across it in a case. We might not have come across it. We might have come across it when somebody was arguing, those things. As a lawyer, we are considered as an expert by the client. He knows the facts. He comes to us with the problem. We should give him the solution under law. Even though we are considered as an expert by the client, a lawyer is not expected to know all branches of law and the law which is applicable under all situations. A good lawyer, I would say, is one who would be able to lay his hands at the right place, the right law, the right section which would be applicable, and then look to the precedents and then frame the case. In that way, when we spend time in preparing for such lectures, I would say that a day or two which I have spent on this subject was really useful to me, that I was able to refresh my mind with regard to various aspects of Transfer of Property Act on which I am going to address today. Like that, persons who are listening to these series of lectures will be able to grasp something out of this, and in future, when situation arises, when a problem comes through a client to him, he would be able to easily lay his hands on the right provision and assist the client in the best possible way using his expertise. The topic which I've chosen today is a small portion of the Transfer of Property Act. Transfer of Property Act is a very vast subject, and for this 1 hour, I thought that a few sections which we may not come across very frequently, but still there is wealth of knowledge that can be gained. I thought that I will concentrate on that. The basic rule in transfer of property is that one cannot transfer more than what he has. Nemo dot quod non habet. No one can transfer better title than what he has. The next principle is that caveat emptor. Buyer beware. You will have to do all your homework, make all the investigation, inquiries, be satisfied with the title, and if you get good title, it's good. If you fail, you will have to blame yourself because it is buyer beware. You can't blame somebody else. These are the two basic principles in transfer property. But however, the lawmakers, with lots of foresight, thinking of various situations which may arise, where there may be equity in favor of the purchaser and estoppel against a transferor, have balanced the interest of both in such a way that if a person acts in good faith, makes due inquiry, believes that the transferor has got right to transfer the property, and for consideration purchases the property, later on, under certain given circumstances, under certain given circumstances, used to dictation, therefore it flowed. Under given circumstances, the transferor cannot deny the title of the transferee, and any person claiming under the transferor also cannot challenge the title of the transferee. There are certain sections which I would refer in the course of today's lecture. They are section 38, 41, 43, 51, 53, and if time permits, part performance 53A, and the pendentility purchase section 52, if time permits. All these sections operate in different fields, are subject to conditions which are inbuilt therein, and if those conditions are satisfied, nevertheless, the transferor at the time of transfer did not have title to the property, the transferee may still get good title if the ingredients of the respective sections are fulfilled. First, let us see section 38 of the Transfer Property Act. Section 38 deals with a situation where power to transfer the property is conferred on a person with a condition that the power can be exercised under given circumstances. In exercise of the power, when the transfer is made, later on, the person who had given the power questions it by saying that the situation under which the property could have been transferred was not existing at the time of transfer, and therefore the purchaser would not get good title. Section 38 says, as between the transferor and the persons who would be affected by such transfer, that is, but for the transfer, if somebody else would have had title, those persons also, as between the transferor and such persons on one hand, and the transferee on the other hand, section 38 says, it will be deemed that the situation which authorizes the person to sell was existing at the time of transfer. The words used in the section is that where any person authorized only under circumstances in their nature variable to dispose of immovable property transfers the property for consideration. Please underline, transfers the property for consideration, alleging the existence of such circumstance. Then, as between the transferor and the transferee, it is deemed that the situation was in existence. Later on, the transferor cannot say the situation was not there and therefore my transfer is bad, please give back the property to me. This is subject to the condition which is inbuilt in the section. It says that the transferee should have taken reasonable care to inquire about the existence of the circumstance, and the transaction should be in good faith. Therefore, three ingredients for this section 38 to operate are: one, transfer is for consideration, the transferee acts in good faith, and the transferee has made a reasonable inquiry to the extent possible that the situation under which he is entitled to sell was really in existence. For example, if the husband gives a property to the wife, subject to a condition that she may alienate it if the money in her hands are not sufficient to maintain herself, and the wife exercises the right and executes the property, executes the sale in favor of the purchaser, representing that the money which is available with her is not sufficient to maintain herself, and the buyer makes reasonable inquiry and is satisfied that yes, enough money is not available with her for maintenance, and values the property for proper consideration which he pays, he buys the property, then this transaction is in good faith and it is protected under section 38. At a later point of time, neither the husband nor the wife nor their children can challenge this transfer by saying that mother had enough assets elsewhere which even by reasonable inquiry the purchaser could not have found out, and because some assets were available elsewhere, there was no occasion for the mother to sell the property. Therefore, the condition which was imposed authorizing her to sell is non-existent, and therefore the transfer is bad. Such a plea cannot be put forth by them because there is a deeming provision contained in section 38. The deeming provision is that it is deemed that the situation which authorizes the transferor to transfer was existing at the time of such transfer. This is a way in which even if the transfer on the face of it may look not proper, is protected by section 38 of the Act. Now we will go to section 41. This is a slightly different provision. On the face of it, it may look against the principles of one cannot transfer what he does not have. Section 41, commonly it is known as transfer by an ostensible owner. Ostensible owner is a person who is not the actual owner, but expresses to others that he is the actual owner, and on such expression, when he is selling the property and the transferee purchases the property or gets an interest in the property for valuable consideration, later on, the true owner cannot come and say that the ostensible owner is not the real owner, and therefore no title will pass to the purchaser, and therefore a declaration that the sale deed is void or voidable and to recover the property. The ingredients which are inbuilt in section 41 are consent express or implied by the person who is interested in the property to another person to act as the ostensible owner. Second is the transfer is for consideration. Third one is that the transferee makes a reasonable inquiry about the right of the transferor to sell the property. And four, just as in section 38, the transferee has acted in good faith. Cases of this nature will arise more among partners, members of Hindu family, co-owners, etc., where the actual owner, by consent express or implied, allows another person to express as if he is the owner and allows him to transfer the property, and believing the said representation to be true, the transferee acts to his disadvantage, that is, parts with consideration and buys the property, which he would not have done but for the statements made by the ostensible owner, which the section says should be with the implied or express consent of the actual owner, then the rule of estoppel will arise. The rule of estoppel will get triggered. But for your representations, the transferee would not have parted with money. The transferee would not have taken the risk of purchasing this property. You having induced him to purchase the property, one, by expressly consenting the other to show that he is the owner, and the other saying that, yes, I am the owner of the property, and then selling it. The two of you together or separately cannot subsequently challenge the title that is claimed by the transferee under the said transaction. There are a few occasions when this section has come up for consideration before the Honorable Supreme Court, and the one which I was able to lay my hands on, AAR 1965, Supreme Court 295, Suraj Ratan Tirani versus Azamabad Tea Company. That is a case where the plaintiffs in the suit purchased the property from the legal heirs of the actual owner. It was a tea estate. The eldest son, who was in management of the family business, had all the revenue records standing in his name at the time when the father, who is the original owner, was alive. After the death of the father, he applied to the revenue authorities to have his name continued in the register. The same was not objected to by the others. They did not specifically write any letter objecting to it. And therefore, the name of the eldest son continued in the revenue records. The eldest son mortgaged this property with the bank. Bank brought the property for sale, enforcing the mortgage. One national company had purchased the property in the mortgage sale. Thereafter, they sold it to the present defendant in the suit. Thereafter, the other legal heirs saying that the eldest son is not the owner of the property, and therefore he did not have any right to sell the property, they challenged the sale. The defense taken was that he was in management, he was allowed to manage the business by all the legal representatives, the revenue record stood in his name, and therefore section 41 would apply and the sale would be protected. Unfortunately for the purchaser, the Supreme Court in paragraph 14 and 15 of the said judgment stated that the defense taken by the defendant, who is a subsequent purchaser of the property, attempting to have the sale of his vendor protected by section 41 was not acceptable. The reason is section 41 specifically says that the ostensible owner should be one who is acting as the ostensible owner with the express or implied consent of the actual owners. In the facts of that case, consent was given to the eldest son only to be in charge of the tea estate and be in charge of the business which was run by the family in the tea estate. Consent to be in management, in the opinion of the Supreme Court, does not amount to consent to be the ostensible owner, and therefore, even if the other considerations, other requirements of section 41, namely consideration, due inquiry, and all other things are satisfied, even then, since the consent express or implied was not there, the sale by the purchaser, the transferee, and the subsequent purchaser is not protected, and therefore it was held that the sale would be good only to the extent of the fraction of right which the eldest son will have in the property and not the entire property. The next case where I saw this section 41 was applied by the Honorable Supreme Court, 1979, 2 SEC, page 601. In this case, the defense which was taken by the buyer was accepted by the Supreme Court. The property belonged to the son. Father, claiming to be the owner and making the purchaser believe that he is the owner, had sold the property for consideration to the purchaser. Son subsequently challenged it by saying that father is not the owner, I am the real owner. But then, in the facts of that case, it was found that son was always with the father when the transaction took place. The consideration was paid by the purchaser into the hands of the son. Son received the consideration. Father executed the sale deed as if he was the owner and son was witnessing it. Therefore, father has acted as the ostensible owner. Son has impliedly consented to that by receiving the consideration for that transaction, where the father is signing as the owner bar vendor, and therefore the son is estopped at a later point of time from saying that father is not the owner, I am the owner, and therefore the purchase is bad. Here again, the rule, one cannot convey a better title than what he has, stands exempted because of applying the principles of equity and applying the principles of estoppel, which is statutorily recognized in section 41. The next case is one where large damage would have been done if the defense was not accepted. It is the case in 2005, 9 SEC, page 375. Crystal Developers versus Asha Lata Ghosh. In that case, property belonged to A. B claimed that A has executed a will and he is the executor under the will, gets a probate without impeding the other persons who would be entitled to a share in the property if it was intestate. On the basis of the probate, he executes a sale deed in favor of a builder. The builder demolishes the existing building, puts up new constructions thereon, executes sale deed in favor of various purchasers. At that point of time, proceedings for revocation of the probate was pending. Ultimately, the probate was revoked, and then the legal heirs who would be entitled to a share in the property if it is intestate, they filed a suit challenging all these transactions and claiming that the transfer which was made by the executor is bad. Other questions arose whether the revocation of probate will take prospective effect and thereby transactions which have taken place in the meanwhile cannot be questioned, or it will date back to the date on which the probate was granted itself. But in this lecture, I am not dwelling on that because that will come under the Succession Act where we are not treading today. The other question which arose here was the buyers pleaded that transfer was made in their favor by an ostensible owner. He was entitled to represent that he had the right to execute the sale deed because under the will, he is the executor. He had a probate backing his claim. Apart from that, it is found on facts of the case, on evidence that even the legal heirs who would otherwise be entitled to the property were along with the executor when he executed the sale deed and did not object to it. 1. 2. For invoking the principles of estoppel, also placing reliance on section 115 of the Evidence Act, the building which was there was demolished, new constructions were put up. At no point of time the legal heirs intervened and said that this property belongs to us. There is a petition for revocation of probate which is pending. Under those circumstances, please don't go ahead with any construction in this property. They did not raise any question. They all aligned themselves with the executor. They only wanted to see that the property was sold some way, and later on they could adjust the proceeds among themselves depending upon the outcome of the proceedings. Be that as it may, the Supreme Court said that the executor was the ostensible owner. The other legal heirs who would be entitled to the property impliedly gave consent to the executor to sell the property, even though he was not the actual owner, because subsequently the probate was revoked. And third, they allowed the purchaser to alter his position to his disadvantage by investing money in putting up new constructions therein and new purchasers coming for the property and then purchasing the property for valuable consideration. Therefore, valuable consideration, ostensible owner, consent implied or express, and estoppel. All these principles were invoked by the Honorable Supreme Court to protect the purchase which was made by various purchasers. If this principle had not been applied by the Honorable Supreme Court and Section 41 had not come to the rescue of the purchasers, then if the probate, cancellation or revocation dates back to the date of the grant of probate, and thereby it is deemed that the probate was not granted at all, then the executor would not have any right to transfer the property, and the purchasers down the line would not get any right. You may just see what would be the plight of all the purchasers. Here is where law steps in for the purpose of balancing the rights of the parties. If the actual owners allow things to happen right under their nose, even though the consent is not expressed, it is deemed and it is implied that they have given consent. And depending upon the facts and circumstances of each case, if it can be established that the consent was actually given or the circumstances show that it is impliedly given, then allowing another person to be the ostensible owner and allowing the purchaser to purchase the property for valuable consideration, thereafter, the true owners are stopped from denying the rights which the purchaser gets. Now, we will move on to the next section, section 43. 43, it is normally known as, the situation is known as feeding the grant by estoppel. In the facts of a transfer, there may be cases where on the date on which the transferor is transferring the property, he does not have right. Thereafter, the transferor who did not have right in the property on the date on which he transferred gets a right to the property. In such a situation, whether the transferor can say, on the date on which I sold the property to you, I did not have title, therefore I could not have transferred title to you, hence give back the property to me. Or whether the legal heirs or anyone claiming under the transferor can say that the transferor on the date of transfer did not have right and therefore the transfer is bad. It does not convey title and therefore declare the transaction as bad and give back the property. This again, under given circumstances, the title which is claimed by the purchaser stands protected. There are cases this way and that way. The conditions for applying this case is that, one, the transferor should fraudulently or erroneously represent that he has title to the property on the date on which he is transferring the property. Two, later on, the transferor acquires title to the property. The 3, the purchaser should purchase the property for valuable consideration. 4, the transfer subsists till the time the transferor has acquired right to the property. That is, if the transferee finds that the transferor did not have title to the property at the inception and he has been duped, he challenges the transferor and asks for the consideration back and has the transfer set aside or avoided at his instance itself. Later on, the transferee cannot say, I did it at a time when you did not have title. Now that you have title, please restore the old title to me. Please restore the benefit which I would get under the transaction earlier under section 43. Such a plea the transferee cannot take. The important condition here is that the transfer should subsist till the time the transferor who initially did not have right to the property gets a subsequent right to the property. Under those circumstances, the transferee will still be entitled to claim that he has got good right to the property, and the defect in title which earlier existed is fed by the subsequent title which he acquires, and therefore the grant which is earlier granted defectively is fed with good title, and the transferor is stopped from denying such title. Therefore, it is called feeding the grant by estoppel. As I told you, the necessary ingredients for this is there should be a transfer, and the transfer should subsist. The transfer should not have been set aside in the meanwhile. For this case, one interesting case came up in 1999, 3 SEC, page 172, before the Honorable Supreme Court. There, the City Development Corporation sold a plot of land in a public auction, and the auction purchaser, who was a successful bidder, paid 25% of the consideration in terms with the tender notice and complied with everything on his part. 1999, 3 SEC, page 172, not 174. Somebody has asked for the correct page number. It is page number 172. 25% of the consideration was paid, and all other conditions in the tender were complied with. But then the transfer deed could not be executed by the corporation for the reason that it was declared that it had become part of Greenbelt. Later on, when the property could be transferred because of some realignment of the areas, the original auction purchaser, who did not get the sale deed executed in his favor, he filed a writ petition under Article 226, pleading equity in his favor, saying that the defect in title which was there earlier now stands cured. The area is transferable. Therefore, please convey the property to me. The mandamus was sought for. High Court granted some via media relief, saying that instead of this property, give a conveyance in respect of some other property of the same extent and same value. Matter was taken to the Honorable Supreme Court. Supreme Court said, first and foremost, Section 43 itself cannot be invoked in such a case, since 43 will come into play only if it is a case of a transfer that is effected. For effecting a transfer, whether there is title in the transferor or no title in the transferor, that will be taken care of by Section 43. But then there should be a transfer. In the facts of that case, the Supreme Court said, inviting a tender, accepting a bid, and accepting 25% of the consideration and not moving further into any conveyance does not amount to a transfer, and therefore, since a transfer has not taken place, the requirement of section 43, namely transfer such property for consideration, such transfer shall be protected at the option of the transferee, does not arise at all. And they also invoke principles of equity and public interest, and said that the conveyance would not be made in favor of the purchaser. So far as 43 is concerned, Supreme Court said it was not a complete transfer. Since it is not a complete transfer, the first limb of section 43 is not satisfied, and hence relief cannot be granted. One very interesting case in the Supreme Court, AIR 1962, Supreme Court, page 847. Here, any one of you, if you have the Transfer of Property Act, may kindly see there may be an apparent conflict between section 6 and section 43. Section 6, if you see, it says that certain transfer, what may be transferred. Property of any kind may be transferred except as otherwise provided by this act or by any other law for the time being in force. Subclause A says that the chance of an heir apparent succeeding to an estate, the chance of a relation obtaining a legacy on the death of a kinsman or any other mere possibility of like nature cannot be transferred. Therefore, as per section 6A, a right which may accrue to a person, a chance of succession, also known as spes successionis, it is not transferable. Therefore, in the facts of this case, it was pleaded that the transferor only had a chance of succeeding to the property, and therefore mere fact that subsequently he got right to the property by inheritance, he cannot protect his title, because as per section 6A, in the first inception itself, the property cannot be transferred. And once section 6A says the property cannot be transferred, then it is void ab initio, and therefore the title of the purchaser is bad. The courts have held that section 6A, if it was left by the parliament with that section alone, without section 43, and without giving room for invoking principles of equity and principles of protecting the title of the purchaser on who is a purchaser by good faith, then the argument under 6A would stand. That will hold good. But then section 43 comes into play, where the commencement of the section itself is that on the date of transfer, he does not have right to the property. That means he does not have the right to transfer. Therefore, as per section 6A, he does not have right to transfer, but still he is executing the transfer. And later on, he is inheriting the title to the property. Under those circumstances, 43 will come into play. 43 will get triggered. And if the circumstances contemplated under section 43 are satisfied, namely fraudulent representation or erroneous representation at the time of transfer. 2, the transfer has not been cancelled by the purchaser in the meanwhile. 3, consideration has been paid. 4, the buyer has acted in good faith. If all these things are established, then Supreme Court in that case, applying section 43 and also section 115 of the Evidence Act, invoking the principles of estoppel, said that the vendor cannot say that at the inception he did not have title. And once the vendor cannot say that at the inception he did not have title, then the title subsequently obtained will also not be there. Such a contention cannot be made. It is against equity, it is against morals, and therefore Supreme Court said that the title which the purchaser has got is a valid title. One other case where a slightly different view has been taken by the Honorable Supreme Court on the facts, which is peculiar to that case, 2015, 5 SEC, page 691. Agricultural Price Marketing Committee versus Bannamma. In that case, mother, who is the actual owner of the property, is the plaintiff. Son, claiming that he is the owner of the property, fraudulently or erroneously, he is conveying the property to B. Subsequently, mother is filing the suit, impleading the son as well as the purchaser and challenging the sale. During the pendency of the suit, son died. Therefore, his legal representatives were brought on record. And during subsequent stages of the proceedings, mother who filed the suit, she dies. After her death, the legal heirs of the son who get the right to the grandmother's property, they are the persons who are the subsequent owners. The contention of the transferee was, yes, son at the time of executing the sale deed did not have right in the property. Now the son's estate is represented by his legal heirs. His legal heirs have now got the right to the property. Therefore, the defect in title of the original transferor gets fed subsequently because the legal heirs step into the shoes of the transferor and they claim right only under him, and therefore the title which the legal heirs get will be sufficient for the original transferee to seek remedy under section 43 and defend his title. This was his contention. This was negated by the Supreme Court by saying the condition contained in section 43 is that the transferor should get the title. That is, reading it carefully, where a person fraudulently or erroneously represents that he is authorized to transfer certain immovable property and professes to transfer such property for consideration, such transfer shall, at the option of the transferee, operate on any interest. This is very important. Operate on any interest which the transferor may acquire in such property at any time during which the contract of transfer subsists. Therefore, two important ingredients are: will operate on any interest which the transferor may acquire. Therefore, the interest should be acquired by the transferor himself. If the transferor dies and his children acquire that right, that is not sufficient. That will not invoke section 43, and the defendant or the transferee cannot say that his children have got the right now, and therefore his children cannot now put me out of the property. Section 43 will apply if all the conditions contained in section 43 are fulfilled. The condition is that during the lifetime of the transferor itself, he should get the right which he did not have earlier. During his lifetime, if he does not get it, that is the end of it. Section 43 will not come. Whether he has got other rights or other defenses is a different question. Section 43 will not come. In that case, Supreme Court negated the plea on the basis that the right which the legal heirs will get will not come to the aid of the transferee because the right did not come to the transferor during his lifetime. Then we will now go to section 53. 53 is dealing with fraudulent transfers. Dealing with fraudulent transfers. A transfer of immovable property which is made with an intent to defeat or delay the creditors shall be voidable at the option of the creditor who is so defeated or delayed. However, nothing will impair the rights of a transferee in good faith and for consideration. The principles of equity come to protect the title of a transferee if the transfer is in good faith and if it is for consideration. This is also subject to the provisions contained in insolvency law, and any suit which is instituted by a creditor or a decree holder cannot be for his personal benefit. It can be only for the benefit of the general body of the creditors. Here, the transfer may be with ulterior motives for the purpose of giving preferential treatment to someone or getting the money and out of the sale consideration paying some of the debts, and thereby the general body of creditors are affected. Rateable distribution is not enabled. Somebody is preferred, somebody is made to go high and dry, and therefore it is a fraudulent transfer. Even if it is a fraudulent transfer, law comes to the aid of a transferee who has purchased the property, provided the purchase is in good faith and is for consideration. There are two reasons for this. If the transfer is for consideration, then no prejudice is caused to any of the creditors. Either the property would be there or property gets converted into money, the money would be there. Two, the purchaser has acted in good faith. He has not colluded with the vendor. He has not colluded with the debtor. Under those circumstances, you cannot deprive him of the title because of some accusing finger which you have against the vendor. A person who has bought the property for valuable consideration and who is not a party to any malafide or bad faith or any collusive action with the vendor, then he has got to be protected. That is the object of section 53. The courts have gone to the extent, many cases will arise under the various revenue laws where assessment proceedings are pending. Substantial amount of liability is fastened on the assessee by the assessments, and thereafter, when they go for recovery, they will find that the property does not stand in the name of the assessee. The property has been transferred in favor of somebody else. Then notice is issued under the tax laws or the rules framed thereunder for declaring that the transaction is bad and for bringing the property for sale. One such case, 1998 6 SCC, page 658, the Income Tax Department wanted to avoid a sale and bring the property for sale for realizing the amounts which were due against the assessee. The plea was that property has been purchased for consideration and in good faith and without knowledge about the tax dues which were pending, and assessment proceedings were only pending at that point of time. Supreme Court said that you cannot invoke the powers contained in your rules and deem that the property is the property of the assessee and proceed against the asset which stands in the name of the transferee. You will have to file a suit if you so deem it necessary to declare that the sale is bad establish the ingredients to show that the transfer is mala fide, or it is not for consideration, or that the transaction is not in good faith. The citation, somebody wants a repeat, 1998 6 SCC page 658. Supreme Court said that the income tax officer will have to file a suit for declaring the transaction as bad, and that also cannot be for the benefit of the income tax department alone. It can be only for the benefit of the general body of creditors. And therefore, the property which is transferred cannot be brought for sale for recovering the arrears of the income tax department alone. One other case, ARL 1962 Supreme Court 370. ARL 1962 Supreme Court 370. Imani Appa Rao versus Gollapalli Ramalinga Murthy. Gollapalli Ramalinga Murthy. In that case, the property was the property originally belonged to A. It stood in the name of A. A sold it to B. B sold it to C. A files the suit that contending that the transfer by him in favor of B was binami, and he had executed such a sale deed only for defeating the interest of the creditors and to defeat and delay the creditors. And he wanted the property to be treated as belonging to his estate so that all the revenues from the property and realization of the property could be utilized for settling his creditors. The property had changed several hands. There are a number of transactions, dates and events in that case. But ultimately the point was that the transfer was sought to be challenged by the transferor, saying that he had transferred it to B fraudulently for the purpose of defeating his creditors, to keep it away from the reach of his creditors, to keep it out of reach of his creditors. Supreme Court, applying the principles of where persons are in position of equal guilt, the position of the defendant is better, and also applying the principle that a party to a fraud cannot take advantage of his fraudulent activity and try to take advantage of his fraudulent deed and challenge the transfer made by him itself. Third is that section 53 will apply only at the instance of a creditor for the benefit of the general body of creditors. It cannot be resorted to or taken advantage of by the transferor himself. So, applying the principles of equity, one who seeks equity will have to do equity. You cannot play fraud, execute a sale deed, and subsequently when the purchaser claims that he is entitled to the property and he sells it to third parties, later on you cannot turn around either on your own or joining hands with the first purchaser and say that my initial sale to you is fraudulent. I wanted to cheat all the creditors and therefore it is a fraudulent transfer. Please declare it as fraudulent. Such a plea is not open to you as you have committed fraud. You cannot take advantage of the fraud. So, by now we have seen section 38, 41, 43 and section 53. There is one other section which can also be referred to here in the context of the judgments which we have already seen, section 51. This can also be seen along with specific relief act where mandatory injunction is sought for. There are line of judgments where the true owner remains silent allows the person who is not the owner of the property to deal with the property, put up constructions in the property, does not object to it at the earliest point of time. Thereafter, he cannot say, the property belongs to me. You have put up constructions in my property, and therefore mandatory injunction to remove the building that has been put up by you and give the vacant land to me. Mandatory injunction, it has been held that it is discretionary and such a relief should not be granted, and the principles enshrined in section 115 of the Evidence Act should also be invoked. And if it is established in a case that by remaining silent, you have made the person who is putting up constructions in the property to believe that he is doing it in his own land, and on such belief, he has invested money, he has put up constructions therein. After all the construction has been put up and completed, you cannot come at a later point of time and say, no, the land belongs to me, and therefore mandatory injunction, remove the building. Similar principles are contained in section 51 of the Act, of the Transfer of Property Act. 51 says, when the transferee of immovable property makes any improvement on the property, believing in good faith that he is absolutely entitled thereto, and he is subsequently evicted therefrom by the person having better title, the transferee has the right to require the person who is evicting him to assess and estimate the value of the improvement that has been made and then pay him for that, or sell the interest in the property at the market value, irrespective of the value of improvement. I have done the improvement, leave it to me, you sell the property to me. These two options are given. When the circumstances aforesaid, the transferee has, yes. Therefore, section 51, the principles of specific relief act for grant of mandatory injunction, and section 115, all these three, if they are read in harmony, then assume the facts of a case. I am the owner of plot A. Plot B has been conveyed to me by another person. Thinking that plot B has been rightfully purchased by me, I am merging plot A and plot B and putting up a massive construction on both the plots. Plot B actually belongs to another person who is the owner of plot C. But still, he does not prevent me from putting up constructions on plot B also. He does not tell that plot B belongs to me, and therefore the transferor to you does not have title, and he remains a silent spectator, allows me to put up construction on plot B also, investing substantial part of money, substantial sums of money. Under those circumstances, if the ingredients of section 51 is made out, namely transferee of immovable property, I am a purchaser of plot B, I have invested money for making improvements therein. Subsequently, the owner of plot C, who is also the actual owner of plot B, gets an order of eviction against me. Then, in defense, I can say, if my title is bad, then please pay me the amount which I have invested in making the improvements. You keep the improvement to yourself. Or, in the alternative, you sell the land to me at the market value. I should not be beaten on both sides. That is there. Another principle of equity, another principle based on good faith and good conscience contained in section 51. Apparently, if you see, all these sections will be against the basic principle that one cannot transfer better title than what he has. Also against the principle of caveat emptor. The buyer will have to blame himself if he has not made proper inquiry and if he has landed up buying a property from a person who does not have valid title. These two are given a setback, are given a go by, and the title of the transferee is protected by law under Chapter B of the Transfer of Property Act, where specifically these sections come to the aid of the purchaser. Now we are at about 5:25. Shall we stop here or refer to 53A, transfer of part performance also? Where is the organizer?
Sir, I leave it to you, sir.
Shall we go on for another 10 minutes?
Yes, sir.
Shall I continue for another 10 minutes?
Yes, sir, please.
Okay, I'll stop with section 53A then. 53A is a provision where the person does not have title to the property. A conveyance in his favor has not happened. But still, law protects his possession. And even the true owner will not be able to recover possession from him. The ingredients which are necessary for section 53A is that there should be an instrument in writing and the terms of the transaction should be ascertainable from such instrument in writing. The person who is in possession of the property should be in possession in part performance of that agreement, or there may be cases where he is in possession already, but then possession should continue in terms of this agreement and not under the original character. I'll come to that in a minute. And he should have performed all that is to be performed by him on his part, or be ready and willing to perform what is remaining to be performed on his part. If all these things are complied with, then the owner of the property cannot recover possession from him and say that the conveyance has not taken place in your favor. I am still the owner of the property, and therefore evict him from the property and recover possession. This will not apply to cases of oral agreements. It will apply only to cases where a person has contracted to transfer for consideration immovable property in writing, signed by him or on his behalf, from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty. Suppose it's a mere letter. I agree to sell the property to you for rupees 10 lakhs and I am putting you in possession of the property. If it stops with that, then a defense under 53A cannot be resorted to, because for specific performance, one of the conditions under the Specific Relief Act is the court should be able to find out what are the actual terms which has been agreed between the parties. If 10 lakhs is the consideration and 5 lakhs has been paid, when the balance is to be paid, when possession has been given, when the registration will take place, what are the other documents which the purchaser has got to give, title, opinion, clearance, all other conditions which are required as per section 55 of the Transfer of Property Act for conveying proper title, what has been agreed between the purchaser and the vendor. These terms should be capable of ascertainment with reasonable certainty from a document in writing. They are the first two conditions. Third one is possession. If a number of cases have arisen, this will arise both under the Rent Control Act as well as under the Specific Relief Act. We would have come across a number of cases where a tenant is in occupation of the property he will agree to purchase the property from the vendor and dispute will arise between the parties. He would have stopped paying the rent, or the landlord will say that I need the property for my own occupation, therefore section 10(3) or section 10(2) for default, whatever it is under the old Rent Control Act. He will file a petition for eviction. The defense will be, I am in possession of the property. There is an agreement to sell in my favor. Under those circumstances, I am not liable to pay rent. That will be the defense under the Rent Control Act. And a suit for injunction will be filed. I should not be evicted since I am in possession under an agreement, invoking section 53A. On both counts, the tenant is bound to fail. The reason is he was in possession of the property as a tenant and continued in possession of the property as a tenant. The third and important ingredient in section 53A is that possession should be with the transferee in part performance of the agreement, and he should have taken possession of the property as a part of this agreement. Of course, courts have come a little away from this by saying that even if he was in possession as a tenant, if the agreement says that on and from this date, he ceases to be a tenant, and on and from this date, he will continue to be in possession of the property in his capacity as a purchaser, then in such cases, 53A will arise, willful default will not come, he will succeed both in the rent control court as well as in the suit for injunction, and he will be able to protect his possession. Therefore, the third ingredient is possession, which may vary from case to case, whether the possession is traceable to part performance of this agreement or it is traceable to any other character. If it is traceable to any other character, 53A defense cannot be taken. If it is traceable to this agreement, 53A defense can be taken. Then, always, as in specific performance, the person who is the purchaser should have performed his part or should always be ready and willing to perform his part of the property, of the contract. If he is not ready and willing and he was not having the wherewithal to purchase the property, and on evidence it is established that he got into the property, even if all the other ingredients are satisfied, there is an agreement in writing, terms can be ascertained, possession has been given under this agreement, 50% of consideration has been paid, he should have paid the balance consideration within a reasonable time. He was ready and willing, but the purchaser has not accepted the consideration and executed the sale deed. I am in possession, please protect me. Law comes to the aid of a person in equity if he is acting in good faith, if his hands are clean, and if he is ready and willing to perform his part. Most of the cases we would see that persons who enter the property later on will lose the interest in performing their part and think that, yes, I am in possession. It will take 10 years for him to take the possession of the property from me. Take 15 years for him to take possession of the property for me. Why should I pay the balance money? Such a person may hold on to possession, but law will not protect him in eternity. 53A will come only if he establishes that he has performed his part or is ready and willing to perform his part. There is one exception to section 53A, just like a specific performance. We will not be entitled to have specific performance against a subsequent purchaser if the subsequent purchaser is one for value without notice of the earlier agreement. Similarly, 53A also cannot be pleaded against a transferee or anyone claiming under him where the transferee is a person who acts for who has purchased the property for consideration and did not have notice of the part performance of this agreement. Suppose in a given case, a person is purchasing the property under a registered sale deed. There is a prior agreement for sale and the agreement holder is in possession of the property. The purchaser has made inquiry on what character he is in possession. And he comes to know that the person in possession has been in possession for a long time as a tenant or as a mortgagee in possession, and therefore believed that the character of possession is not as an agreement holder, and therefore he did not have knowledge about the part performance, and he thought that the possession is as a tenant, and therefore I can buy the property and later on file a suit for recovery of possession. In such a case, if the transferee makes out that he is a bona fide purchaser for valuable consideration without notice of the part performance, then 53A will not be applicable. The equities between the two has to be balanced, and law balances it in such a way that you are a person who is an agreement holder in possession, performed your part or ready to perform your part. The other person is a purchaser of the property without knowledge about your agreement and without knowledge about your part performance possession. Under those circumstances, equity will tilt more in favor of the purchaser and less in favor of the agreement holder, and therefore under such circumstances 53A will not apply. Therefore, analyzing all these sections, we can safely come to a conclusion that the framers of law, as early as 1882, when the Transfer of Property Act has been enacted, have taken into consideration several circumstances, permutations and combinations, several defects that might arise, under several circumstances it may arise, how it is to be protected, when it is to be protected, under what circumstances it is to be protected, and have given inbuilt safeguards in each one of the provisions and ensured that the right of a bona fide person, a person who has acted in good faith, a person who has paid the consideration of the property, such person is protected. And that is why we framed our topic for today's lecture as applicability of the principles of equity in the Transfer of Property Act. These are all exemptions to the basic rule that one cannot transfer more than what he has. And I think with this, we will we would have gained something with regard to these sections of the Transfer of Property Act. And I again say that all this is not for the seasoned practitioners who day in and day out plead this and prove this and argue this in court. It is all for persons who are interns, persons who are students stepping into the courts and the entrance in the profession, so that they will pick up something from here, gain momentum and shine in life. Thank you very much for your patient hearing.
Thank you, sir, very much for your insightful views. Even the seasoned practitioners here are.
Asim, you're not audible. Little more. Increase your
yes, sir.
Volume.
Can you hear me now, sir?
Still, it is not.
Sir, thank you very much for your insightful views, sir. All of us, besides being practitioners, are always eager students of law.
Tell me. Yes. Now it's clear.
Sir, with your permission, can we throw this virtual floor for questions to the
yes.
to those who have been listening to you?
Yes.
சின்ன பிராக்சர் மாதிரி இருந்துச்சு. நேற்று காலையில பால் வாங்க போன இடத்துல வண்டி ஸ்லிப் ஆயிடுச்சு. வெயிட்ல காலையில பால் கார்டு வாங்க போனேன்.
Type the question, or you could ask the question. We would enable the mic. So there was one question that came from Aarti.
Yes.
Vedavel, can you enable the mic for Aarti?
If I'm wrong, anybody can correct me also.
So good evening. I'm Aarti here. Thank you for a very, very useful and informative session. Like Asim said, I don't think it has to do anything with your seniority, because everyone are learners, and honestly, this session has been very helpful. So just very quickly, my question was, you spoke about section 38.
Yes.
Can it be used or applied in a scenario where an agent sells an immovable property, and
Yes.
later on there is some defect found in that property? This is notwithstanding laws of agency under Contract Act.
Yes.
But, since the property here is an immovable property that is being sold by an agent, can we apply the principles of section 38 when the power of attorney is found defective? Say the principles are challenging the authority given to that agent, but the transferee has purchased it from the agent, has been in possession of the property for many, many years.
Yes.
But later on, there is a case filed by the principals challenging that authority that was initially given.
Yes.
So just
See, in
want
such cases, section 38 will not, 38 cannot be invoked. There are a number of cases where they say all these will give an unconditional right. The word used for the Supreme Court is this: unconditional right will flow to the transferee. But however, it is subject to satisfying the conditions which are inbuilt therein. That is, the title which will flow to him will be unconditional at the end, provided the conditions contained in that section is satisfied. The condition contained here is that for section 38 to apply, a person, there is no dispute with regard to the right at all. The right in the property is there with A. A is authorizing B to sell the property under certain circumstances. That is, if you want to make money for the purpose of raising funds for performing a marriage, yes, you go ahead and sell the property. Then a marriage is fixed. The property is sold for realizing consideration. Subsequently, the marriage does not take place. Even under those circumstances, the circumstance for which the property was sold is existing. This will not cure a defect in title. My straight answer to you is that if there is a defect in title, or if there is a defect in the power of attorney, section 38 will not arise. Section 38 defense cannot be taken.
Right. Thank you, sir.
Probably if the defect in title was at that point of time, subsequently title is acquired, section 43 may come. Feeding the grant of estoppel will come.
Okay.
Section 38 will not come.
Okay. Thank you, sir.
Okay, thank you.
So there's a question from the audience, if there is any citation for section 53A.
Just a minute. I'll give you. 53A, note down the citations. 2011, 13 SCC 232, 2004, 8 SCC 614, one earlier case, 1969, 3 SCC 120, and one more, 2001, 1 SCC 414.
Thank you very much, sir. If there is any question that any of you may have, can you kindly type your question so I can put it to the learned senior?
Okay, don't trouble the listeners.
All right, sir. I think you've been very clear. You've left no room for doubt.
Oh, okay. Thank you.
Thank you very much, sir, for enthralling us with your lecture.
I thank BFS Legal, who is always close to my heart, and Asim, who's so good to me for having given me the opportunity to be the lecturer in the first lecture which is organized by them. And
thank you so much, sir.
Thank all of you. Have a good evening, and let's come back to court very soon.
Hopefully, sir. Thank you.
Okay. Thank you.
Thank you.
Okay. Bye.